It's very good to be here, working in the Commission's legal service with responsibility for competition law and in particular responsibility for questions relating to the European competition network. I often find myself at large multilateral gatherings of network members, but unfortunately there's very little opportunity to interact directly with one or another competition authorities. So it's very pleasant to be here. I see we've got quite a wide range of subjects to get through this afternoon. Now, I have the advantage of having my linguistic incompetencies overcome thanks to this little device. The same benefit has not been afforded to you, I notice. And I have given myself a stern talking to about the need, when discussing complex economic assessments, to avoid complex sentence structures. If I do wander off into some labyrinthine explanation, then do please interrupt me and ask me to explain it more clearly. Professor Sanduli mentioned the great interest that there is in damages actions and follow-on damages actions. I'm going to address the prior question of whether there can indeed be a follow-on action, because the question is whether the decision which is to provide the basis for a follow-on action will survive judicial review in Luxembourg. Indeed, in the United Kingdom, under the Competition Act, the limitation period for bringing a follow-on action is set by reference not to any fixed period, but by reference to the lapse of time since the end of proceedings in Luxembourg to determine the question of the validity of the decision, which is intended to provide the basis for the follow-on action. You have 2 years as from the end of the proceedings in Luxembourg. So, to turn to proceedings in Luxembourg, judicial review by the European courts of Commission decisions, by way of general background, there's nothing new in the treaties as a result of the Lisbon Treaty in terms of the direct provisions. What were Articles 81, 82, now Articles 101, 102, have been left unchanged. There are some other changes, though, which might be of some significance, and some which certainly will be of significance. Some of you might have noticed that the Lisbon Treaty has omitted what was Article 3F of the EEC Treaty, which made express reference to competition policy as one of the activities of the community. There was a fear that this meant that there was some sort of downgrading of the status of competition law. The court seems to have been on the case with remarkable alacrity, because in just about the very first opportunity presented by the Tilia Sonera case, they took the opportunity to blur the line between the old treaty and the new treaty to make it clear that, as far as the court is concerned, competition is still very much a central preoccupation of the treaty. Probably of far greater importance is the upgrading of the status of the Charter of Fundamental Rights, so that that now has the status equal to a treaty itself. And looking further down the road, the EU is committed by Article 6.2 of the Treaty on the European Union to accession to the European Convention on Human Rights. How this is all going to work procedurally in terms of the toing and froing between the court in Strasbourg and Luxembourg, and what influence it will have on the substantive work of the court in terms of the standard and approach to judicial review, that all remains to be seen. There is, for the time being, just a communication by the presidents of the respective courts about possible ways in which the workings of the two courts might interact. I'm going to speak this afternoon really in two sections. First of all, about what's usually called in English the review of legality, and then speak about the court's exercise of its unlimited jurisdiction. Well, as regards review of legality, as I'm sure you know, this is governed by Article 263 of the treaty as it is now, which is set out in the handout. The problems that frequently beset applications by private parties under Article 263, namely the question of whether the applicant is or is not directly and individually concerned by the act in question, is one that usually doesn't arise in competition cases because certainly since the abolition of the exemption system under Regulation 17, overwhelmingly all direct actions in the General Court brought under Article 263 are brought by persons who are addressees of decisions. There are one or two exceptions in the recent practice. One can think, for example, of the Al Rosa case, a case which was brought by a party who was very substantially affected by the giving of commitments to the Commission by De Beers, but the question of admissibility didn't detain the court for very long in that case, and in most competition cases the question doesn't arise. There has, however, been very vigorous debate in recent years about the adequacy and intensity of judicial review of competition decisions by the court in Luxembourg. It has been a particular preoccupation of the applicant bar that the court has given excessive deference to the Commission's margin of assessment, with the court limiting its control to manifest errors of assessment. And I've indicated in a footnote just a very small selection from the vast amount of literature that this subject has generated in recent years. I particularly draw your attention to the article by President Jaeger of the General Court, which is a very interesting analysis of the issue from the court's perspective, although unfortunately Judge Jaeger wrote that article before the European Court of Human Rights gave its judgment in Menarini and before the Court of Justice gave its judgment in KME. So it's interesting to compare what Judge Jaeger's thoughts were, unalloyed by those two judgments, with the actual outcomes of those judgments. I think that a lot of the concerns that have been expressed are essentially semantic issues. They are problems of language rather than anything else. Certainly from where I'm sitting when defending Commission decisions in court, we don't have any sense of comfort as regards the primary issues of fact. Was somebody at a meeting? Or, of course, on any question of law. Those are subject to the fullest intensity of review. It's true that the court has deferred to the Commission on complex economic and technical assessments, and the great difficulty is to determine what is a complex economic or technical assessment. And with a particular view to the impending accession of the European Union to the European Convention on Human Rights, there's the now omnipresent element of fundamental rights being invoked in cases down in Luxembourg. And as I'm sure you all probably know, the Court of Human Rights addressed this question recently in Menarini Diagnostics, because it's a case about an AGCM decision imposing a fine of some 6 million euros, so quite substantial, but not by the standards of Commission fines particularly high. And to, I think, nobody's great surprise, this was classified as a criminal proceeding by the court, although precisely where it lies on the spectrum of criminality is not entirely clear. There's another earlier case, Judicial, which admits of the possibility of a spectrum of levels of protection that must be observed with respect to matters that are classified as criminal, and precisely where competition proceedings lie on this spectrum remains to be clearly identified. I think we're some way away from the hardcore of criminal matters involving personal responsibility for serious criminal charges, such as murder, although very often those cases are prayed in aid nowadays in competition cases. Now, as regards the rest of the judgment in Menarini, it's probably not the last word on the subject, because the judgment, certainly of the majority, is rather abstruse and brief in its findings. The Italian court's powers of review, as I understand it under national law, were limited to a review of legality, but the European Court of Human Rights found that the national court's powers in fact went further and enabled it to exercise full review over the AGCM's decision. And the difficulty of discerning where we stand after Menarini is not aided by the fact that the reasoning is so succinct. And a counterpoint to that is a much more detailed dissenting judgment, where the analysis of what Italian courts could or could not do is not always easy to reconcile with what the majority decided. The majority judgment holds that the National Court was able to exercise review over all matters, including technical matters. But then, if one refers to the dissenting judgment in Menarini, one finds that it said that the National Court didn't have power to review technical questions. So it's quite hard to know really where we stand after Menarini. All I would say is that Menarini is only a case about one decision and the adequacy of review of that decision. And it doesn't, even if we take simply the majority judgment alone, it doesn't preclude the possibility of a different outcome in another case, even in another case concerning a similar system, if on the facts the judicial review that was carried out was found to have been inadequate. There's another relatively recent case from the court in Strasbourg called Sigma Radio and Television, which is about a judgment of a court in Cyprus, which makes this point very forcefully, that it is only determining whether the judicial review carried out by the national courts was adequate in that particular case. And the dissent is very far-reaching in this case. It seems even to go to the point of challenging Judicial. If one looks in paragraph 9 of the dissenting opinion, there's a very emphatic passage about how administrative authorities should not usurp the jurisdictional prerogatives. In the end, however, it does seem to me that there is consensus between both the majority opinion and the minority dissent as to the acceptability of the basic structure of having a system where an administrative authority can impose a fine, provided it is subject to full review by a court, because the dissenting judgment ends on an optimistic note at paragraph 12 by noting that the Italian legislator had seen the error of his ways and had changed the law subsequently to allow for full review. So despite what the dissenting judgment of Judge Pinto de Albuquerque says about the usurpation of the jurisdictional role by administrative authorities, in the end, in the light of the subsequent change to Italian law, he does seem to accept, as of course do the majority, that it is acceptable to have a system such as you have here and such as, of course, we have at the level of the EU, where an administrative authority takes the decision, which is then subject to judicial review, provided it is subject to full review. Now, as to what might be full review and as to the adequacy of the system in Luxembourg in fulfilling that requirement, there are some indicators given in the Court of Justice's judgment in the KME cases. But first, if we just go back to what Judge Jaeger wrote in tempore non suspecto before the judgment in KME, he was inclined to give a fairly narrow margin for manoeuvre to that category of matters that were deemed to be complex economic questions and thus subject to a certain degree of deference in judicial review. He says that just because something involves detailed econometric studies, that can't imply limited judicial review, because that would just be a way of the court taking a shortcut due to pressure of time by saying this is all very complicated. We have 800 pages of economic expert reports, therefore it's complex, therefore we won't give it close scrutiny. He then asked the question, does it encompass economic reasoning that has to be applied to a puzzle of facts and as a result becomes hard to decipher? Again, he dismisses that possibility and in the end confines that limited area of review to where the Commission is essentially making economic policy choices. That, I think, is not quite, though, the response of the Court of Justice in KME, although KME is also another judgment that is hard to read and is perhaps not as helpful as was commonly supposed when it first came out. The difficulty of KME is, first of all, that the court, unlike the European Court of Human Rights, the Court of Justice in KME avoids taking a position on whether competition proceedings are to be classified as criminal. So the extent to which the particular protections afforded by other parts of Article 6 of the Convention on Human Rights, which specifically relate to criminal matters, how far the court accepts that those apply to competition proceedings in Luxembourg is left unclear. Also, an element that is commonly forgotten about KME is that KME, the KME cases, were appeals about the level of the fine. The subject matter of the appeal didn't actually extend to the substantive findings of fact of the Commission and consequently the court at first instance. Indeed, the cases at first instance were only about the fine. So dicta that one can pull out of the judgment in KME about substantive review need to be treated with a certain caution. What one finds in the judgment around paragraph 92, 93, 94 is what appears to be, in the context of the case, essentially no more than an obiter dicta about the standard of review, where the court essentially goes no further than transposing into cartel practice the dictum from Tetra Laval about how, although the Commission has a margin of discretion with regard to economic matters, that does not mean that the courts must refrain from reviewing the Commission's interpretation of information of an economic nature. Not only must those courts establish, among other things, whether the evidence relied on is factually accurate, reliable and consistent, but also whether that evidence contains all the information which must be taken into account in order to assess a complex situation and whether it is capable of substantiating the conclusions drawn from it. That doesn't in itself help us very much in defining what is a matter that is to be deemed as complex. And as regards that list of things that the court is entitled to check, it doesn't tell us very much about what they're going to do and the intensity with which they're going to do it in any particular case.